Right, ladies and gentlemen, welcome to my YouTube channel. So the last time we talked about searches, and I said today we'll continue by talking about arrests. Now, of course, you know that when somebody commits an offense, because this is criminal litigation, when somebody commits an offense, we want to bring the person to court. Yeah, we want the court, because of course, you know, section 36 of 5 is of the opinion that everybody is presumed innocent until proven otherwise. So where do you prove otherwise? In court, right? How do you now bring somebody to court in order for you to now come and start proving his non-innocence, or start proving that he actually committed an offense? So we have arrest, because of course you have to arrest the person and bring the person to court. So apart from arrest, there is still what we call summons. So if you complain to a judge that, see, this person actually committed an offense, instead of issuing a warrant to a police officer, the court can issue summons to the actual person. So while warrant is issued to the police or anybody that would arrest the person, summons are issued to the person actually that committed the offense, or that is alleged to have committed the offense, in order for the person to come. So you are summoning the person, while warrant is that you are giving it to the police officer to go and arrest the person. So I hope you have known the difference between warrants and summons. But let us just start from somewhere. Arrest. One thing you have to know about arrest is that arrest violates your personal liberty, your right to personal liberty, which is under section 35 of the Constitution. And when arrest is being done, it is expected that it is done within the ambit of the law, so that it would not, because of course when you look at section 35, it does not make your right to personal liberty sacrosanct. Of course, there are exceptions as to where that your right to personal liberty can be infringed. Yeah, so there are exceptions. So when the police or any enforcement agency reasonably suspects that you have committed an offense, he looks at you and he reasonably suspects. So the reasonable suspicion does not have any measurement to it. So you can be looking like you are a criminal, and even though you did not commit an offense, the police can look at you and reasonably suspect that you have committed an offense and come and carry you. You cannot now say that he has infringed your right because you did not commit any offense. Of course, how is he supposed to know that you did not commit any offense? He reasonably suspected that you committed an offense. Now, when it will now be wrongful is when he does not follow the law when he's arresting you. For example, when he arrests you, maybe your reasonable suspicion that you have committed an offense, he's supposed to tell you that, see, you're under arrest because you are under arrest for committing this offense. Maybe it's possible that you might not have committed it, but he must have to explain to you in the language you understand the particular offense that you are being arrested for. That's number one. Number two, when he arrests you, of course, he's supposed to investigate even before arresting you. But then, let's say because it's reasonable suspicion, he's expected to charge you to court within 24 hours if there is court within 40 kilometers radius. If there is no court within 40 kilometers radius, he's expected to charge you to court within 48 hours. Now, if he does not do these things, then it is a wrongful arrest. That is when you can now maintain an action of fundamental rights against the police. But this is to tell you that in order to bring somebody to court, because what we are looking at is criminal litigation, we are not trying to arrest somebody just for the purpose of arresting. So you're arresting somebody for the purpose of bringing the person to court. But apart from arrest, there are also other processes you can use to bring someone to court. Number one is arrest with warrant. Number two, arrest without warrant. And number three, summons. We will take it ad seriatim. Ad seriatim means we will take it one after the other. So when we look at arrest with warrant, because we'll start from there. What is warrant of arrest? Warrant of arrest is like an authority. In fact, it's an authority in writing, mandating or ordering the person that it is being written to arrest a named person. So in warrant of arrest, the person that they want to arrest, his name will be boldly stated there. The offense that he has been alleged to have committed would also be stated there, and there will be like an order to that person that a warrant is issued to please arrest this person and bring him before this court. Now, warrant of arrest can be issued after summons have been issued and disobeyed. We will still come to where the circumstances wherein warrant of arrest can be used. But one of the circumstances, when we come there, we'll still explain it. One of the circumstances is when a summons have been disobeyed. Summons is singular. Summonses is the plural, so that you not think that I'm making mistake in English. So when a summons is issued, and of course I told you that summons is usually issued to the person that actually committed the offense. So when they now summon you, they issue you the summons. It's also in writing too, by a judge or something, and you do not obey the summons, now the court can now issue a warrant of arrest. So it is within his discretion. He might say, okay, let me issue summons first, then before warrant of arrest if you do not obey the summons. Or he can say, let me just go ahead and issue warrant of arrest first. So who issues warrant of arrest? A judge, a magistrate, and justice of peace. These people issue warrant of arrest. However, it is different in the north and it's different in the south. So in the north, that is where you see justice of peace. South, it's only a judge and a magistrate that can issue warrant of arrest. In the north, that is when you can now add justice of peace. However, the Administration of Criminal Justice Act that is applicable to Abuja and the national courts, of course, if you want to know about the legal framework we are using, go to the first video on this playlist where I introduced criminal litigation, you would see it. So the Administration of Criminal Justice Act is silent on whether a justice of peace can be empowered or has the authority to issue warrant of arrest in Abuja or in the national courts, like in the National Industrial Court, Federal High Court, and all that. So now, these are the ones that I've mentioned. This means, remember, I did not mention police officer. So police officer cannot issue a warrant of arrest. It might come out in your exams. They will not tell you that the IGP, the Inspector General of Police, the highest ranking member of the police, has issued a warrant of arrest. They say comment on the validity or otherwise of the warrant issued by the Inspector General of Police. I am not telling you that a police officer, no matter the rank, can never and cannot issue a warrant of arrest. A warrant of arrest is only issued by a judge, magistrate, that's in the south, a judge, magistrate, and justice of peace in the north. So there is no police anywhere. So who is a warrant of arrest issued to? Number one, a warrant of arrest is issued to a named police officer. They might say, hey, Inspector this, arrest this person. And Inspector this is supposed to arrest this person. It might be issued to generality of the police people, just the whole policemen, or maybe the, I don't know how police have their divisions, maybe Aba division or, you know, Aba company, Aba barracks. I don't know how they have their divisions. It might be issued to the whole of the police people in Aba, that this is the person we are looking for, arrest the person and bring to court. Or it can be issued to a private person. So I would not really be giving the sections, but the sections are there. Go to your ACJA, ACJL Lagos, and ACJL Kano to look for the sections. Now, when you look at section 4 of the ACJA, you can effect an arrest by just touching the suspect. Yeah, you can touch the suspect and just confine the suspect and, okay, let's go. You do not need to use force. You don't need to start beating. You know how police people arrest people here in Nigeria? With total disregard to the law. The person you're arresting is agreeing with you, is following you, but you not be beating the person, slapping the person. That is an abuse. That is against his right to dignity of human person. If the person wants to sue you, he can sue you and get damages from all those beatings. So you do not need to be beating or using force. However, you can use reasonable force. Now, listen to what I'm saying. Reasonable force in the following circumstances. You can use reasonable force in this. Now, ordinarily, you're not expected to use any form of force. However, reasonable force can be used in the following circumstances. Number one, when there is a reasonable apprehension of violence. So the person you want to arrest, you know that is a violent person. Maybe the person you are trying to go and arrest is an armed robber. Yeah, there's a reasonable apprehension of violence. You know that this person will not just succumb. This person already has weapons that he would use for you when you come around, because he doesn't want to be arrested. So when there is reasonable apprehension of violence, you are expected to use reasonable force. That's number one. Number two is when there is an order of court to that effect. When there is an order of court to that effect. So the order of court, it is in the order of court that when you are arresting this person, use force. Because if you don't use force, I'll fire you. So you use force there. When there is an attempt to escape, so you are trying to arrest somebody, the person is not succumbing to your authority as the police. I say, enter the vehicle. He's trying to escape. You can now use force. Reasonable force. For the safety of the suspect or the person effecting the arrest. So you can use reasonable force for the safety of the suspect. Now, people might ask, how are you going to be ensuring the safety of the suspect when you're arresting the suspect. Like, what is not the... No, you know, in Nigeria, we have what we call jungle justice. So when somebody commits an offense and they want to kill the person, you can use reasonable force to arrest the person and take the person out of there so that they would not, for the safety of the suspect or the safety of the person effecting the arrest. So you want to be safe, you are trying to arrest the person. Of course, this also has some kind of intertwining with reasonable apprehension of violence, because you want your own safety as the person that is effecting the arrest, so you must have to use reasonable force. So how do you now make complaint in order for warrant of arrest to be issued? You make complaint through writing, information on oath. So you bring your information on oath through writing and you submit it to the judge. So it must be on oath, of course. So if you are lying, it will now be perjury, and perjury is when you lie on oath. So it's not an offense. So you have to be very careful by complaint in writing and on oath. So it should also be noted that warrant of arrest is issued any day, including Sunday or public holiday. Now, under what circumstances, we have not come there. I said that we'll be here. Under what circumstances do you issue warrant of arrest? There are 3 circumstances you can issue warrant of arrest. 3. Number 1, when the law stipulates it. When there is a law. Now, most of the crimes or most of the offenses as being stated in the criminal code or even in the penal code most of the offenses can have a clause where it says that this person will not be arrested if not with warrant. So if it is being stated by the law that when you want to arrest somebody that committed this offense, you must use warrant, then use of warrant is indispensable in that circumstance. That is number 1, law stipulation. Number 2 is disobedience of summons. So we've come here again. So your exam might come like this. Somebody has been issued a summons and he refused to go. What, in your opinion, is the possible or the next process, supposing you are the judge? So you already know that one of the circumstances of issuing a warrant of arrest is when a summons is being disobeyed. So that is the second circumstance where you can issue a warrant of arrest. Number 1, law stipulation, where the law provides for it. Number 2, disobedience of summons. Now, number 3 is when it is a serious offense. Serious offense, then warrants can be issued. Warrant of arrest can be issued. So when it's a serious offense, it's possible that the summons would not be issued. You just go ahead to reissue the warrant of arrest because it's a serious offense. So warrant of arrest, I know I told you it can be issued any day. It can also be effected or executed at any day, anytime. Yeah. So how is it effected? When the person that has been named has been arrested by the person that it is issued to. What do I mean? If it is issued to me as a police officer to go and arrest one Mr. Mbeke, it is effected when I have gone to arrest Mr. Mbeke. And again, let me throw this in. Arrest in lieu is prohibited. You cannot arrest somebody's wife because I just said Mr. Mbeke and Mrs. Mbeke. If you go to look for Mr. Mbeke and you don't see Mr. Mbeke, you go back. You cannot arrest Mrs. Mbeke in place of Mr. Mbeke. So most of the times you see this thing happening in real life in Nigeria. Mr. Mbeke is in the warrant of arrest, or let's even not say that he's in the warrant of arrest. He committed an offense, or he was alleged to have committed an offense, and you want to go and arrest Mr. Mbeke, maybe because of a petition that was written. When you get there, you would not see Mr. Mbeke, but you saw Mrs. Mbeke, the wife. And you now go to arrest Mrs. Mbeke. In your mind, why you did that is so that when Mr. Mbeke comes back and they tell him that they have arrested Mrs. Mbeke, Mr. Mbeke will now come to the office, to the police station, and you now arrest him and release Mrs. Mbeke. So that is not a good way to apply the law. And the law has prohibited it. Stricto sensu, you cannot arrest somebody in lieu of another. Another one is that you cannot arrest somebody for a civil wrong. When I mean civil wrong, you know your classifications of law, civil and criminal law. So I'm not going to enter into all those things. So let us say you have breached a contract. Somebody is owing you money. Instead of you to issue, in civil litigation, we call it summary judgment procedure. So when you come under the summary judgment procedure, when somebody is owing you, and the person does not have a defense to the claims that you are claiming, then you come under summary judgment procedure or undefended list in Abuja. You know, when we do civil litigation, you understand all these things. So when you, instead of you to come under that, you are now involving the police to arrest the person because the person is owing you, or because the person breached the contract that the two of you entered. So that is a civil wrong. You cannot, the law has stated it, that you cannot arrest somebody for a civil wrong. Somebody, a tailor is with your clothes. He has not delivered it. You now carry police to go and carry the tailor. That is not how it's supposed to be. You sue the tailor. And the court will now order the tailor to compensate you. So, okay, now that you have arrested the tailor, has your clothes come out? So where can a warrant of arrest be executed? It can be executed anywhere apart from these places. Number one, a court where the court is sitting. In a courtroom where a court is sitting. Except with the permission of the court. So you cannot arrest somebody where a court is sitting, in the courtroom. A warrant of arrest cannot be executed there. That's what I mean. A warrant of arrest cannot be executed in a courtroom where a court is sitting. However, in Lagos, in ACJL Lagos, section 27 sub 2, it did not mention the phrase, is it phrase they call it now, where a court is sitting. The statement where a court is sitting. So we can now infer that even when a court is not sitting in Lagos, you cannot effect a warrant of arrest. So you must have to note all these details. In Lagos, it did not say where a court is sitting. We just said in court. If we are to use the literal rule of interpretation, I hope you remember your canons of interpretation. If we are to use the literal rule of interpretation, or what we call the expresso unis est excluso alteris rule, that is, the express mention of a thing is to the exclusion of others. So if we are to use all these things, it means that when a court is not sitting, you cannot effect a warrant of arrest in a courtroom in Lagos. So that is that for that. So, if you look at section 23, paragraph B, and section 25 of the Legislative Houses, Powers and Privileges Act 2017, you would see that no member of the National Assembly can be arrested in the premises of the National Assembly. So you cannot effect a warrant of arrest within the premises of the National Assembly if you want to arrest a member of the National Assembly. Now, note, I did not say staff. So you can go and arrest the staff there, but you cannot arrest the members of the National Assembly within the precincts of the National Assembly. Maybe outside the premises you can arrest them, but within, the law has stated it clearly that you cannot arrest. Now, can you execute a warrant of arrest outside the jurisdiction where it is issued? So I am in Abia State, and I want a warrant of arrest to be executed in Lagos State. And the person that I want to be arrested is in Lagos State. And I have gotten a warrant of arrest for the person to be arrested in Lagos State. How am I supposed to do that? So, will I just go to Lagos and arrest the person and come back to Abia? No, you don't do that. Now, it is different state to state it is different from when it is within the same state, but different division, different magisterial district or different judicial division. So, for example, in Abia State, we might have the Aba Judicial Division and we have the Umuahia Judicial Division. In Lagos State, we might have the Ikeja Judicial Division and we might have the Apapa Judicial Division. So, if a warrant of arrest is issued in Apapa Judicial Division, can I come to Ikeja Judicial Division and arrest the person without recourse to courts in Ikeja Judicial Division? So, the procedures are different. Now, listen and listen attentively. So, I will start from one state, but different judicial division or magisterial district. So, we are in Imo State, and a warrant of arrest has been issued in Olo Judicial Division to go and arrest somebody in Owerri Judicial Division. Now, this is the same state, but different judicial division. If it's magistrate, it's different magisterial district. What do? You carry the warrant of arrest and you go and effect it first. You go and arrest the person in Owerri Judicial Division. But before you go back to Olo Judicial Division that sent you, you must have to carry that person that you have arrested to the court in Owerri Judicial Division in order for the court to endorse removal, number one, and grant bail if it is a bailable offense. So, endorsing removal is with the knowledge and with the satisfaction that this particular warrant was issued according to law and issued by a competent authority. That is when he can endorse removal. So, the Owerri judge will now say, okay, I have seen that it is actually according to law. This person actually was alleged to have committed an offense and it was issued by a competent authority. So, I endorse removal. He can also grant bail if the warrant came with some kind of endorsement of bail. So sometimes the warrant can come with you can issue bail, you can grant bail, but make sure that, these are the conditions we follow. So if those kinds of endorsements are there, that's over a judicial division judge can grant bail. So what do I mean now? Although has issued a warrant of arrest, you have gone to Owerri judicial division, the different judicial division to arrest. You will not go first to the court to go and, before you go arrest. You go and arrest first, then carry that person to court in Owerri. So it's now Owerri judge will now endorse removal after being satisfied that, number one, that warrant was issued by the law and it was issued by a competent authority. That Owerri judge can also grant bail to that person you have arrested. That is one state but different jurisdiction or judicial division. However, in different states, I have issued a warrant of arrest in Kaduna. I want to go to Nasarawa state to effect arrest. Now, it is different states now. You don't just enter into Nasarawa and go and arrest the person first. You have to go to the court in Nasarawa first. You have to now go first to the judge in that other state. Remember, if it is the same state and different judicial division, you don't go to the judge first. You go and arrest first, then come to the judge later. But in different states, you go to the judge first. The judge will endorse after being satisfied that this particular offense that you want to arrest person is an offense in that state, number one. And number two, it is issued by a competent authority. So if the court is satisfied and answers these questions in the positive, is this offense an offense in this state? And was it issued by a competent authority? It was not issued by a competent authority. This was a policeman that issued this thing. He will not endorse removal. He will not even endorse the warrant first. So you must be sure that it was an offense where you are coming from, and it was the competent authority that issued the warrant before he can now endorse it and say, okay, go. So when you now arrest the person, you have to bring that person back to that court that endorsed that warrant when you came. And that person will now endorse removal or grant bail if it is a bailable offense. So now this thing I just talked about is when state high courts are issuing warrants. However, if it is a federal high court, that issued in Imo State and say go and arrest somebody in Kano State, you can enter Kano State and arrest the person and come back, because why? Federal High Court is one all over Nigeria. See the case of Abiola against FRON. Federal High Court does not have, you cannot say state to state, no. Carry the person from Kano, come back to Imo State where the listing was given. So that is that about arrest with warrant. Now, arrest without warrant. Where can a police officer arrest without warrant? I will read them out to you. Number one, where an offense is committed in the presence of a police officer. So if police officer is just walking on his own, he did not come to arrest you. It's that time that your village people know that they will put inside your mind for you to go and steal somebody's bag. So, and the police officer now saw you and caught you, so they can arrest you. Even though the offense you committed in his presence, he provided by the law that you must arrest with warrant. He doesn't need to arrest you with warrant since you committed the offense in his presence. Number two, when a person is having in his possession instrument of housebreaking without excuse. So I saw the instruments and equipment they use in doing housebreaking, that you have them. You can be arrested, sir, without warrant. So, and you don't have any reasonable excuse. They ask you, why are you with these things? You are saying that, you are surprised you saw it in your hand. They will come and say, I'm surprised, I'm arresting you. So yeah, to the van. So that one is without warrant. Obstruction rule, when a person obstructs a police officer while carrying out his duty. So when a police officer is trying to carry out his duty and you are coming there to stop him, they will arrest you with those people they came to arrest without warrant. Deserter rule, when he suspects a person is a deserter of any armed forces in Nigeria. So when you are in the armed forces, of course you know that cowardice is an offense in the armed forces. So when you desert the armed forces and they see you anywhere, they can arrest you without warrant. Another one is escape rule, when you have escaped from lawful custody. So they arrested you, you escaped. They can arrest you without warrant. So probably they arrested you with warrant. And that's the offense that you have to be arrested with warrant. And when you have been arrested with warrant, you escaped. They can arrest you back without warrant. So you can go ahead and read most of them. So of course, I didn't mention the three people that can arrest you: police officer, judicial officers, and private persons. Private persons can also arrest you without warrant, and the circumstances they can arrest you without warrant are: number one, any person who is reasonably suspected to have committed an offense which is a felony. Any person who is reasonably suspected to have committed an offense which is a misdemeanor by night. Now, see the difference. Number one, a private person can arrest you without warrant when you commit an offense that is a felony, generally. You can also arrest you when you commit an offense that is a misdemeanor at night. If it is a daytime, the private person cannot arrest you. So read section 12 of the ACJL Lagos. Then indictable offenses. Indictable offenses. Any person who commits an indictable offense, that is an offense triable on information in his presence. So a private person can arrest you without warrant when you commit an indictable offense. So I've talked about a police officer arresting you without warrant, the circumstances. I've talked about the circumstances wherein the private persons can arrest you without warrant. Also, a judicial officer can arrest you without warrant or order for your own arrest without warrant within the division or district to which he is assigned. So that is it. Now, when a private person arrests somebody, you're a private person, you arrest somebody, you are immediately expected to go and give the person that you have arrested to the police or any enforcement agency. Maybe if you arrest somebody that was doing drug offenses, expected to go and give him to the NDLE or even the police. And when you bring the person to the police, what's the police supposed to do first? MCQ question. What's the police supposed to do? The police is supposed to rearrest the person. So you bring somebody, and now if you waste time without any, if you waste time on due delay to bring the person to the police, you might be sued to court for false imprisonment. And of course, let me state this: no matter how wrongful your arrest was, you cannot stop the criminal proceeding against you. You know, this Nnamdi Kanu case that they extraordinarily renditioned him back to Nigeria without following the process of extradition. So he was not saying that the court does not have jurisdiction. No, the court will hear the criminal matter against you, but the best you can do is to sue for wrongful arrest and probably get damages. But if you actually committed the offense and they proved you beyond reasonable doubt, you go to jail, but they will still give you your damages if you are successful in that civil suit. Let's talk about summons. Like I said, summons is issued to you that committed the offense to come to court. And when you disobey summons, that is when they can now issue you a warrant of arrest. So what's the lifespan of a summons? It it remains in force until it is executed or cancelled. So when it remains in force until you answer the court. So what is now execution of summons in different jurisdictions? Why am I sounding different jurisdictions? Because they come with your questions like that. A summons has been issued and is to be executed in another state. What are the procedures? Now, when a summons is served outside jurisdiction, what happens is that the court issuing the summons, we send a duplicate copy of the summons to the court in that state or in that other jurisdiction. And that other court in that other jurisdiction that we received the duplicate copy will now treat that summons as if it is coming from him. That is, I am in Abia State. I want a summons to be executed in Kano State. The court in Abia State, we send to the court in Kano State a duplicate copy. And the duplicate copy of the summons, as received by the court in Kano State, will now be treated as if that summons was originally issued by the court in Kano State and will now direct service as if it is him. Do you even understand what I'm saying? You don't understand. I don't know how to explain to you again. So that is that. Effects of failure to obey summons is warrant of arrest is issued. So before I go, I know I've talked about some constitutional safeguard of a suspect that is being arrested. Number one, you must have to be told your offense, information in writing. Section 35 sub 3 of the Constitution, Federal Republic of Nigeria, 1999 as amended, within 24 hours, and in the language he understands. Information should be given to the person that you have arrested on the facts and grounds for his arrest. Information in writing, in the language you understand. You are entitled to it. If you are being arrested, you are entitled to information in writing, and that's section 35 sub 3 of what you were being arrested for. Silence, you have your right to remain silent. Nobody is to cajole you into saying something that will implicate you. You did it, right? You did it, and they'll be beating you. You have your right to be silent until your lawyer comes. And silence in criminal litigation or criminal law is not admission. Silence is not admission. In civil litigation, it can be admission, but silence is not admission in criminal litigation. So you must charge the accused to court within a reasonable time. Section 35 sub 4 and sub 5 of the Constitution, Federal Republic of Nigeria, 1999 as amended, stated something about, I think it's section 35 sub 5, that stated what a reasonable time is. And that is 24 hours, within 24 hours if the court is within 40 kilometers radius, and within 48 hours if the court is not within 40 kilometers radius. So you also have your rights to legal aid. So you don't have money, you have your rights, the court can provide a lawyer for you, or you have your right to legal aid, and that is under section 3 sub 1 to 3 of the ACJL Lagos. So when next I come, we'll look at drafts. We'll look at drafts. After looking at drafts, we'll now look at a lot of tasks, a lot of pre-class assignments, and we'll look at to solve pre-class assignments on arrests, searches, and summons. So I hope you will understand these things as I've stated them. So how we'll do it is that when I call out the tasks, when I call out the question, when I read the scenarios, and of course I call out the questions, I expect you to answer them before you watch my own correction on the questions. So until next time, take care.